You're being questioned during a pre-trial deposition, and now the opposing attorney who is questioning you doesn't believe your answers. What do you do in that instance? Would you like to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, you keep going. You keep telling the attorney the answers that you believe to be true. Don't worry about the fact that the defense attorney is incredulous, that the defense attorney is making snide comments, or clearly giving you the impression that he or she does not believe your answer. You want to know why? A deposition, a pre-trial question and answer session under oath, is designed to find out from you exactly what happened in your own words. It's designed to learn exactly what happened, what you remember happening, and ask you about conversations, ask you about your understanding and, importantly, your memory about the events that occurred. It makes no difference whatsoever what the defense attorney believes. Now, keep that in mind. I'm going to say that again. It makes no difference whatsoever about what the defense attorney believes. Now, why is that? It's because the defense attorney wasn't there. The defense lawyer doesn't know the details of what happened to you. They only know based upon the reports that they have in their file, as well as conversations they've had with their client. That's all. The moment someone asks you a question and they don't believe your answer, you don't have to justify to them anything. All you have to do is continue answering the questions to the best of your ability. Now, there's a difference between saying, I don't know something, and saying something that's totally untrue. That's totally different. That in many of these medical malpractice cases, accident cases, and even wrongful death cases, there are always disputes. There are factual disputes. Disputes about what somebody said. Disputes about what somebody did. Disputes about the different actions that were taken. Now, why are there factual disputes? It's because people have different perspectives. People don't remember every single thing that went on. So just because you may have a different opinion or a different version or a different recollection of exactly what happened compared to this attorney's client, the doctor whom you have sued, does not mean that you are not credible. It does not mean that you are not correct. It does not mean that you are not believable. The most important thing to focus on is not the attorney's attitude when they tell you, really? That's what he said? Because number one, that shouldn't happen. That's not professional. Number two, you are there to answer the defense attorney's questions. And if that's what you remember, then that's your sworn answer. And by the way, the answers that you give to these questions carry the same exact weight as if you are testifying at trial in front of a judge and in front of a jury. So the mere fact that the attorney gives you some attitude and clearly exhibits the fact that they don't believe what you are saying doesn't mean a hill of beans, and thinks that by expressing the fact that they don't believe you, that somehow you're going to change your opinion or change your answer. Well, my suggestion is you tell them exactly what you believe to be true, and that's it. And you disregard the attorney's attitude, and you disregard any nasty or snide comments that the attorney makes, because those should not be happening. Instead, you are there to tell the truth, you are there to explain what happened, and importantly, you are there to tell them what you remember happening. And if their version differs from yours, so be it. So why do I share this quick information with you? I share it with you to open your eyes to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.